Cameron here at Soren Law, and today we're going to be talking about Little Sisters of the Poor versus Pennsylvania. One of those rare Supreme Court cases where it's a 7-2 decision, and yet it promises future litigation. Now, this entire case surrounds the so-called birth control mandate of the Affordable Care Act. Partly the reason why I say that it's so called is that it's not really expressly derived from the Affordable Care Act itself. So the Affordable Care Act instructs health plans to provide coverage for, quote, additional preventative care and screenings. That's it. That's the language. Additional preventative care and screenings for women. That's the entire language that allegedly is a mandate for birth control. Now, carrying out this charge of reading that particular language, you've got the Health Resources and Services Administration, which is a division of the Department of Health and Human Services, which is not in any way going to get confusing, I assure you. Originally, when the Affordable Care Act was passed, they issued guidelines that health care plans provide access to FDA-approved contraceptives to women at no cost under these plans. So that's where the mandate actually comes from. It's this federal agency taking that language, additional preventative care and screenings, and going, okay, we're going to provide this particular preventative care, if you will. All right, move on to 2014, and then you get the case of Burwell versus Hobby Lobby. And there the Supreme Court ultimately ruled that a corporation, a private business owned by a devoutly religious family who objected to providing contraceptives to their female employees with access to contraceptives could opt out. All right, then you move on to 2017, and the Trump administration issues new rules that extend the exemption on the birth control mandate to cover private employers that have religious objections to providing their female employees with contraceptives. So it's kind of, if you will, a codification of Burwell. Now, in response to this, two states, Pennsylvania and New Jersey, object, and they file suit in federal district court. They essentially have two main arguments. One, that the expansion of the exemption violates the Affordable Care Act. And then the second argument is that this expansion of the exemption violates the Administrative Procedures Act. Essentially, they didn't follow the proper procedures that ultimately govern federal agencies. All right. So they go to the federal district court. Federal district court agrees with the states and enters a nationwide injunction preventing the new guidelines and expanding the exemption from going into effect. Go to a federal appeals court. Federal appeals court agrees. And then you've got the Little Sisters of the Poor, which is a religious organization that provides help for the elderly, as well as the Trump administration, reach out to the Supreme Court and say, hey, we think they got it wrong. Can you please hear this one? Supreme Court hears oral argument via telephone in May, and then we get a 7-2 decision saying, nope, states are in the wrong. Clarence Thomas writes for the court, for the majority of the court. The first argument that he handles is that this expansion of the exemption violates the Affordable Care Act. Now, Clarence Thomas's argument essentially goes like this. The Affordable Care Act only authorizes this department to identify what preventative care these health care plans should provide, not necessarily to create exemptions from that. The Affordable Care Act essentially gives unbridled discretion to this agency to decide what counts as preventative care and screenings, and since it's virtually unchecked in that way, it's unchecked in other areas, including the ability to identify and create exemptions from those very guidelines. Thomas then moves on to essentially address a point made in Justice Ginsburg's dissent, addressing the fact that the majority's decision ultimately is going to leave a lot of women without access to contraceptives, or at least no cost contraceptives through their health care plans. Thomas is very quick to point out that if Congress actually wanted to ensure this result, that there were no exemptions on this so-called health care mandate, they could have been explicit about it, and they weren't. All they said was additional preventative care and screenings. That doesn't sound like a mandate from Congress, Thomas argues. So if anyone's to blame for this, it's Congress, not necessarily anybody else. Now, Thomas then moves on to a series of arguments that deal with the Religious Freedom Restoration Act, which was a law passed back in 1993, and it bars federal laws from placing a substantial burden on an individual's free exercise of their religion. Now, since in Thomas's view, these agencies have broad authority to, either hand out additional care or create exemptions, it may not have been strictly necessary for it to consider the Religious Freedom Restoration Act as part of this. However, they certainly were free to do so, and it seemed appropriate for them ultimately to do so. Essentially, we're going to get to what he's responding to in Justice Alito's opinion. Justice Thomas then addressed the state's arguments that the exemptions were invalid because the federal agencies did not follow the proper procedures when it comes to rulemaking. Now, just so you have a little bit of a broad sense here, federal agencies, when they're promulgating rules, have to first issue their proposed rules, then have a period of time for public comment, where they get input from whoever wants to give their input. And then after getting all that input, they issue their final rules. Well, in this instance, their initial rules they put out there for everyone to comment on, and their ultimate final rules, they were pretty similar. There weren't a lot of changes involved. And so the state's argument essentially was, see, they really weren't considering all of this public input. It really calls into question whether they had an open mind, so on and so forth. However, Thomas is pretty quick to point out, all that matters is whether the departments actually follow this procedure, not necessarily that they change the initial rule to the final rule a whole bunch, and points out some cases in which the Supreme Court's made that pretty clear. Now we go to Justice Alito's concurring opinion, and he's joined by Justice Gorsuch. And essentially, his opinion is that the Religious Freedom Restoration Act compels the department to ultimately create this expanded religious exemption or something close to it. And if we, as the court, or at least 5 justices, would rule that, we'd bring this entire thing to an end and be done with it. Thomas ultimately does not reach that one, doesn't want to reach further than he ultimately has to rule, so he doesn't touch it. And essentially he's joined by Kavanaugh and Roberts. Now, Justice Kagan filed a concurrence, essentially agreeing with the result and disagreeing with the reasoning. Now, in her view, the federal government has interpreted the Affordable Care Act to give the Health Resources and Services Administration the power to create exemptions from the health control mandate, and she would simply defer to this long-standing and reasonable interpretation. One kind of wonders the way she's phrasing all of that, whether she may have had a hand in that interpretation during her time at the Solicitor General's office. Don't know. Maybe reading into things. However, she notes that we still have this outstanding issue that the lower courts haven't addressed and we, the Supreme Court, haven't addressed, and that is whether these expanded exemptions are arbitrary and capricious. That is, do they fit the standard of being the product of reasoned decision-making? Did they actually go through and balance all the various different factors and think through this entire thing before they came to a decision? And she suggests that it may ultimately come up short in that regard. And so this is just going to continue this long-standing litigation. In her view, these guidelines could potentially allow publicly traded corporations to claim a religious exemption, and that causes concerns. Now, personally, I don't read the guidelines as being able to go that far. But for the moment, assuming that Kagan's interpretation is the correct one, I'm wrong, that is a very serious and legitimate concern. Then we have Justice Ginsburg, joined by Justice Sotomayor, issuing a very sharp dissent. Essentially, she says, look, you, the majority, totally cast aside the countervailing rights and interests in the zeal of securing religious rights to the nth degree. This decision, in her view, leaves female workers to fend for themselves and having to seek contraceptive sources other than their employer's insurer. And that this ultimately will likely leave somewhere between 70 and 125,000 women without access to no-cost contraceptive services. So she's very unhappy in that regard. So why does this promise to be a case that's going to be litigated? Well, because as is Kagan noted in her concurrence, we still haven't reached the issue of whether these expanded exemptions fit the category of being arbitrary and capricious. And it's important to point out that Justice Roberts just recently was involved in writing a majority opinion in which he opined the Trump administration failed to meet that relatively low bar. So he's not simply going to give a free pass to an administrative agency. It's entirely possible when this comes back around to the Supreme Court, which it probably will, Roberts is going to take a serious eye at that. He's not going to simply give the little rubber stamp of approval. So, as always, I hope you've enjoyed this video and found it informative.